Understanding the executor office and use of the executor letter, based on exacting transcriptions, 99+% accurate, of notes from Dave Clarence training calls through November 28, 2010 and David Clarence email responses to questions. Definitions: adjourned, to put off, defer, postpone. Black's Law Dictionary, 4th ed., adjourn, early 14c, assign a day, from o.fr. Adjourner, 12c, meet, at an appointed time, from the phrase adjourn to a stated day, a to plus adjourn day, from L. Dinner Staley, see diurnal. The sense is to set a date for a re-meeting, meaning to close a meeting, with or without intention to reconvene, is from late 15c, meaning to go in a body to another place, 1640s, is colloquial. The unhistorical D was added 16c. Related, adjourned, adjourning. http://www.etymnline.com/ signed die, without day, without assigning a day for a further meeting or hearing. Hence, a final adjournment, final dismissal of a cause. Black's Law Dictionary, 4th ed., adjourned signed die. Arrogated, claimed by undue pretenses. Webster's Dictionary 1828. Arrogate. 1530s, from L. Arrogatus, pp. Of arrogate, to claim for oneself, see arrogance. Related, arrogated, arrogating. http://www.etymnline.com/ chattel. An article of personal property, any species of property not amounting to a freehold or fee in land. The term chattels is a more comprehensive one than goods, as it includes animate as well as inanimate property. Black's Law Dictionary, 4th ed. Chattel. Early 13c, chattel property, goods, from o.fr. Chattel chattels, goods, wealth, possessions, property, profit. Cattle, from ll capital property, see cattle, which is the o.n.fr. form of the same word. Application to slaves, 1640s, is a rhetorical figure of abolitionists, etc. http://www.etymnline.com/ constructive trust. A trust raised by construction of law, or arising by operation of law, as distinguished from an express trust. Wherever the circumstances of a transaction are such that the person who takes the legal estate in property cannot also enjoy the beneficial interest without necessarily violating some established principle of equity, the court will immediately raise a constructive trust, and fasten it upon the conscience of the legal owner, so as to convert him into a trustee for the parties who in equity are entitled to the beneficial enjoyment. Hill. Trustees, 116, 1 Spence, J. 511. Black's Law Dictionary, 1st ed. Decedent, a deceased person. Black's Law Dictionary, 4th ed. An individual who has died. The term literally means one who is dying. http://legaldictionary.thefreedictionary.com/decedent, origin, 1590 to 1600, eldest dent, s. Of des to ns, departing, withdrawing, prp. Of decedia. Etymologically the word denotes a person who is dying. Black's Law Dictionary, 1st ed. Estate. The word estate is a word of the greatest extension, and comprehends every species of property, real and personal. It describes both the corpus and the extent of interest. It signifies everything of which riches or fortune may consist. Black's Law Dictionary, 4th ed. Estate, early 13c, rank, standing, condition, from Anglo-fr. Estat, o.fr. Estat, state, position, condition, health, status, legal estate, mod.fr. 8r, from L. Status, state or condition, from root of stare to stand, from pi base status stand, see stat. For initially, see especial. http://www.etymnline.com/ especial, late 14c, from o.fr. Especial preeminent, important, from L. Specialist belonging to a particular kind or species, from species kind, see species. Latin words with initial sp, st, sc usually acquired an e when borrowed by Old French. Modern French has restored the word to special, originally with the same sense as special, later restricted to feelings, qualities, etc. http://www.etymondline.com/ a special. Late 14c, from o.fr. A special preeminent, important, from L. Specialist belonging to a particular kind or species, from species kind, see species. Latin words with initial sp, st, sc usually acquired an e when borrowed by Old French. Modern French has restored the word to special, originally with the same sense as special, later restricted to feelings, qualities, etc. http://www.etymondline.com/ Executor, General Executor. A General Executor is one who is appointed to administer the whole estate, without any limit of time or place, or of the subject matter. Bouviers, Law Dictionary, 1856 edition. General Executor, one whose power is not limited either territorially or as to the duration or subject of his trust. Black's, Law Dictionary, 1st ed., Executor, he to whom another commits by will the execution of his last will and testament. William C. Anderson, A Dictionary of Law, 1893, General Executor, an executor whose power is unlimited as to time, place, or subject matter. William C. Anderson, A Dictionary of Law, 1893, Executor de son tort, executor of his own wrong. A person who assumes to act as executor of an estate without any lawful warrant or authority, but who, by his intermeddling, makes himself liable as an executor to a certain extent. If a stranger takes upon him to act as executor without any just authority, as by intermeddling with the goods of the deceased, and many other transactions, he is called in law an executor of his own wrong, de son tort. 2b1 com. 507. Black's first Executor, 25. An executor de son tort, or of his own wrong, is one, who, without lawful authority, undertakes to act as executor of a person deceased. To make fin executor de son tort, the act of the party must be, 1. Unlawful. 2. By asserting ownership, as taking goods or cancelling a bond, and not committing a mere trespass. Dyer, 105, 166, Crow. Illers. 114. 3. He is, in general, held responsible for all his acts, when he does anything which might prejudice the estate, and receives no advantage whatever in consequence of his assuming the office. He cannot sue a debtor of the estate, but may be sued generally as executor. 26.2. The usurpation of an office or character cannot confer the rights and privileges of it, although it may charge the usurper with the duties and obligations annexed to it. On this principle an executor de son tort is an executor only for the purpose of being sued, not for the purpose of suing. In point of form, he is sued as if he were a rightful executor. He is not denominated in the declaration executor, de son tort, of his own wrong. Bouviers 1856. Occupant, person having possessory rights, who can control what goes on premises. One who takes the first possession of a thing of which there is no owner. One who occupies and takes possession. One who has the actual use, possession or control of a thing. Black's Law Dictionary, 4th ed. Occupant. 1590s, from L. Occupantum, nom. Occupans, prp. Of occupa to take possession of, see occupy. http://www.etymondline.com/ occupancy. 1590s, condition of being an occupant, from occupant. Meaning fact of occupying is from 1833. http://www.etymondline.com/ ordinary, civil and eccles. Law. An officer who has original jurisdiction in his own right and not by deputation. 2. In England the ordinary is an officer who has immediate jurisdiction in ecclesiastical causes. Company, lit. 344. 3. In the United States, the ordinary possesses, in those states where such officer exists, powers vested in him by the Constitution and acts of the legislature. In South Carolina, the ordinary is a judicial officer. 1 rep const.ct. 26, 2 rep const ct. 384 Bovier's Law Dictionary, 1856. Register or registrar, an officer authorized by law to keep a record called a register or registry, as the register for the probate of wills. Bovier's 1856. Registrar. 1670s, shortening of registry. 1540s, from ML registrarius, one who keeps a record, related to register. http://www.etamonline.com/ register for the probate of wills. An officer in Pennsylvania, who has generally the same powers that judges of probates and surrogates have in other states, and the ordinary has in England, in admitting the wills of deceased persons to probate. Bovier's 1856. Probate, the act or process of proving a will, the proof before an ordinary, surrogate, register, or other duly authorized person that a document produced before him for official recognition and registration, and alleged to be the last will and testament of a certain deceased person, is such in reality. Black's Law Dictionary, 4th ed. Common and solemn form of probate. In English law, there are two kinds of probate, namely, probate in common form, and probate in solemn form. Probate in common form is granted in the registry, without any formal procedure in court, upon an ex parte application made by the executor. Probate in solemn form is in the nature of a final decree pronounced in open court, all parties interested having been duly cited. The difference between the effect of probate in common form and probate in solemn form is that probate in common form is revocable, whereas probate in solemn form is irrevocable, as against all persons who have been cited to see the proceedings, or who can be proved to have been privy to those proceedings, except in the case where a will of subsequent date is discovered, in which case probate of an earlier will, though granted in solemn form, would be revoked. Black's Law Dictionary, 4th ed. Probate of a will. 2. The officer who takes such probate is variously denominated. In some states he is called judge of probate. In others register, and surrogate in others. Vide 11 Van Ab. 5812 Van Ab. 126 2 Sup. Tovs. Junior 227 1 Salk. 302, 1 Phil, F. 298, 1 Stark, F. 231, note, and the cases cited in the note, and also, 12 John. R. 192, 14 John. R. 407 1 Edward R. 266, 5 Rawle, R. 81 N. and MCC. 326, 1 Lee, R. 287, Pennsylvania R. 42, 1 Pick. R. 114, 1 Gallus. R. 662, as to the effect of a probate on real and personal property, Bovier's 1856. Surrogate. In some of the states, as in New Jersey, this is the name of an officer who has jurisdiction in granting letters testamentary and letters of administration. 2. In some states, as in Pennsylvania, this officer is called Register of Wills, and for granting letters of administration in others, as in Massachusetts, he is called Judge of Probates. Surrogate. Early 15c, from L. Surrogatus, pp. Of surrogate put in another's place, substitute, from sub in the place of, under plus rogate to ask, propose, see rogation. http://www.etamonline.com/ warrant. VT1. To authorize, to give authority or power to do or forbear anything, by which the person authorized is secured or saved harmless from any loss or damage by the act. A commission warrants an officer to seize an enemy. We are not warranted to resist legitimate government except in extreme cases. 2. To maintain, to support by authority or proof. 4. To secure, to exempt, to privilege. 6. In law, to secure to a grantee an estate granted, to assure. Webster's Dictionary, 1828. Warrant N. Early 13c. Protector, defender, from O.N.Fr. Warrant, O.fr. Guarant, from Frankish warrand, cf. Ohg to authorize, warrant, g. Durant to grant, from p.gmc. War to warn, guard, protect, perhaps from base were to cover, cf. L. Verary to observe with awe, revere, respect, fear, gk. Arrows watchman, horan to see, hit. Werite to see weir. Sense evolved via notion of permission from a superior which protects one from blame or responsibility, c. 1300, to document conveying authority, 1510s. A warrant office in the military is one who holds office by warrant, rather than by commission. http://www.etamonline.com/warrant, v. Late 13c, to keep safe from danger, from o.n.fr. Warrantor, o.fr. Guarantor, from warrant, see warrant, n. Meaning to guarantee to be of quality is attested from late 14c, sense of to guarantee as true is recorded from c. 1300. http://www.etamonline.com/will or testament. The legal declaration of a man's intentions of what he wills to be performed after his death. Company, lit. 111, Swinb, pt. 1, s. 2. 1, Shep, touch. 398. Back. Wills, A. 2. The terms will and testament are synonymous, and they are used indifferently by common lawyers, or one for the other. Swinb. P. 1, S. 1. 5. Back. Wills. A. Civilians use the term testament only. See testament. 13. It is a rule that the last will revokes all former wills. It follows then that a man cannot by any testamentary act impose upon himself the inability of making another inconsistent with and revoking the first will. Back. Wills, E. Swinb. pt. 7, s. 14. 14. A will voluntarily and intentionally made by a competent testator, according to the form required by law, may be avoided. First, by revocation, see revocation. Back. Wills, G1, Van. Devise, P. 1 Roll, Ab. 615, Dig. Estates by Dev, F. And, 2D. By fraud. Estate name. The all caps name estate. The word that does not appear on the birth certificate in front of the all caps name and is not part of the name of the estate, so don't put it in front of the estate name. So, all caps name, estate, or in other places where the word the should appear first, use the all caps name estate. Note the comma or lack of a comma in these examples. However your name as presented on your birth certificate is how you should present it in all your documentation. Whether the name is in upper and lower case letters or all caps letters, be sure to use it as all caps for the name of the estate. If you have used junior, senior, etc. all your life, but it is not written as such on the birth certificate, don't use it as part of the estate name. Conform exactly to how your name is written on the birth certificate and do it in all caps. General information about the estate. Creation of the estate. When you were born, a certificate of birth was created with your all caps name, which was the creation of an estate by that all caps name. The word estate is deliberately left off the all caps name on the birth certificate to hide it. The all caps name is an unincorporated association, an estate. The all caps name is a decedent. The estate was created for your benefit and use, with you as the grantor, by placing your landmarks, footprints, on the certificate of birth, and you are still alive. Your parents are the creator of the estate. They created you. A marriage is a trust. When a birth occurs, the mother is coerced into signing the birth certificate as a trustee, so now the entities of the world can go after the trustee. The birth certificate refers to her as the informant. Your first, lawful, act was putting your footprints on your BC, and after that you were in the world. Being in the world has to do with being legal, not lawful. The corporate state did not create the estate. The grantor did so with the footprints on the document. The estate died and your father, and finally you become the executor in the executor office. You are an earthly estate walking around. the grantor continues to live, and when he or she dies, a certificate of death will be issued. The certificate of birth or live birth certificate is the public record of the estate, and that the estate is probated. It is recognition by the world of the grantor's footprints, will, because the seal and signature is on the certificate of birth. This is not prima facie, at first sight, on the first appearance, on the face of it, so far as can be judged from the first disclosure, presumably, a fact presumed to be true unless disproved by some evidence to the contrary. Black's Law Dictionary, 4th ed., proof. Rather, it's certified proof, finished, adjourned, done, a judgment, that the estate has been probated. It must be an estate, because a trust cannot come before an estate. A trust can only exist if there is already an estate in existence. The address of the estate is the file number on the birth certificate. The estate resides at the file number. The estate is restricted to the file number. It cannot move anywhere else. When asked, "Where do you live?" "Right here." "Where are your belongings?" "I'm homeless." They cannot discriminate against you when you say you're homeless, because you are saying you have no corporate residence. A copy of the birth certificate is proof of the estate. Other proofs of the existence of the estate are bills, mortgage papers, credit report, the driver's license, etc. that have the all-caps name. Never use a social security card as identification. The SS Trust is what they are using against you. David Clarence explains who can have an estate. Note: a certificate of citizenship or naturalization certificate is not a substitute for a certificate of birth. A certificate of citizenship does not create an estate, so a person who has been naturalized does not have an estate, if he comes from a country that does not issue birth certificates. If a man marries a woman who becomes naturalized in America, the wife's social security trust comes under the husband's estate. If you do not have a certificate of birth, you cannot occupy the executrix office. If the country where you were born belongs to the IMF, there's a good chance there is an estate. If the name on the birth certificate is in all caps or has a bond number on it, that's a good indicator of an estate. Our bodies are composed of mostly water and the remainder from the earth. We are each a walking, talking independent island, country, nation or independent state, estate, status. Nature of the estate. Note: never refer to the estate as your estate, but for convenience and economy of words in this document, the compiler is doing it anyway. The all-caps name is foreign to the US and the states. Statutory admission that the estate and executor office are immune from the jurisdiction of the United States and the states is found in the Foreign Immunities Act, because the estate is a creditor. In 28 U.S.C. 1300, 8 al. FCA, foreign state means foreign estate. Just substitute the word estate for the word state, when reading the Act. The estate and the man functioning in the executor office, when located at General Post Office, United States Minor, Outlying Islands at zip +4, 000009998, are foreign states, as described in the Act, equals estates and executors. Foreign Sovereign Immunities Act, FCA, applies because the estate is foreign. Act use MOI. Link to the Act, http://www.law.co.uk/use_sup_1_20/10_20_97.html. You do not own the estate. It's the grantor's estate. It's not your office. The grantor has liability. You do not want to own it, because ownership creates liability. However, you can control the estate and its assets. The estate is in the nature of a trust, but is not a trust. The estate is non-corporate. The estate is subject to trust law and is affected by probate law. Probate law is the highest form of law. Scripture is trust and estate law, and trumps all other law that is, treaty, civil, criminal, law of nations, domestic, probate, equity, just made up rules for the world game, for lawyers to control everything. True law has to be simple and work equally for everyone equals equality. UCC is not contract law because there's not full disclosure. The estate is a realm of action that is a combining of the physical and spiritual aspects of each individual. The estate is older than any form of law or legal issue that is in or around the world today and has been passed down through generations, having come from God. As such, No form of law, other than scripture, can access or penetrate the truth of the estate. The executor office is or appears to be as high as or higher than the term of sovereign, that is ruler, pope, king, or any other illusion of man's superiority, as some understand it. With this level of power, the office is in a position to operate, in private or public, on equal or higher rank than any other as long as it is done in honor and without causing or creating harm or problems for others. All are warned to not attempt to utilize the estate for impure intent. Evil or selfish intent will come right back into your face full force. Point of clarification and distinction. When someone dies, there is an estate created that goes through probate. That estate is a worldly estate of a dead person that is involved in commerce and that has tax liability. It is different from the estate created by your birth certificate. Executor office. Until recently, everybody has abandoned the executor office and the estates. Once you occupy the executor office, you cannot be considered or called chattel. Why are we authorized to occupy the executor office? When you were born, you were sent the executor office, the birth certificate, and then only 3 people could get a copy of your birth certificate: you, mum and dad. Once you reached the age of maturity, 21, you became the only one authorized. As such, one cannot operate as the occupant of the office and then attempt to operate in a different capacity as well, that is as a trustee or beneficiary in a trust, or even in a different capacity, for example as a damaged party or citizen, in order to be able to bring a legal action into something that would be termed as a lower court with less power than the executor office. To do this would be indicative of having a double mind. A house divided cannot stand. That is precisely what the barflies have done to us, lured us into functioning in a trustee capacity under the Social Security Trust, so we are then held liable for the charges. When the executor office is occupied, all lower officers or false officers are naturally bound to perform the highest level of service possible, so the executor is protected and the office is defended. Once you step up and occupy the executor office, then there are no longer any trustee positions. When functioning in the executor office, it cancels out all trustee functions. It overrides them all. However, the executor office can appoint trustees to accomplish certain limited tasks, but can never grant general power of attorney over estate affairs. When you function in the executor office of the estate, you deny everyone from exercising a presumption of authority to administrate the estate. Thus, the executor office would or should have no reason or need to ever consider a legal action in a lower system, as the office has the authority to submit either an order or request to lower office enforcement holders to perform corrective actions. The executor office is the court, as the sovereign is in equality. Definition of court: Black's Law. The sovereign with their real retinue wherever they may be is the executor office. Operating in the executor office entails that all acts or actions of the executor are done to expand or increase the estate and better our fellow man and woman, as commanded by the first executor of the first estate Yahweh. Then, this would allow the executor to operate in commerce under normal life, with honor and truth, in positions of employment or self-exchange, or in no position if that is the choice, as long as no harm is caused, noting that commerce is the law merchant and the opposite of the golden rule. Thus, one is able to operate without needing as much and working with others, as an association or assembly, and can operate much more simply and equally with other executors in exchange. Remember, a trust is a contract, and pursuant to USA Constitution, Article 1, Sec. 10, CL 1, no state shall pass any law impairing the obligation of contracts. In essence, an estate or trust, contract, is private law between the parties thereto. No one, not even the courts, have the authority to look into the business of the estate. The executor never turns over any estate records. The executor has immunity and only has liability if he or she commits a fraud in the administration of the estate. Showing your footprints is a liability. Shows you are the actual grantor. They will never ask for your footprints. It is understood that we have the authority to administer the whole estate, so there is no need to use the title General Executor in deference to executor. See definitions above. By using the words executor or estate, you become the creditor. Creditors have immunity from the debtor. Mail the executor letter to the executor office, yourself, as proof that you occupy the executor office. The goal desired by becoming the occupant of the executor office for the estate is to come out of the world system and be separated therefrom. Making public notice of taking occupancy of the executor office is not necessary, and perhaps not desirable. The king does not need to notice the subjects of his function. Do not make an executor office seal. An executor office seal takes you back into the world. Your signature is your seal. You can use your right thumbprint in red, if you wish. To prove that you are the occupant of the executor office for the estate, make a FOIA request under the Privacy Act to the IRS and the report received back will show you as executor of the estate. Send the FOIA request to IRS Disclosure Office. Do not be representative for the executor office. That is fatal to the functioning in the executor office, estate, as highest court. The registrar is the probate court, not the judge in the probate court. In Great Britain, just as in the United States, the registrar is the court. The probate court is the paperwork at the registrar's office. The probate court just approves what the executor has already done. The executor office is higher than the probate court. The courts do not have jurisdiction, in person or subject matter, over the estate. The only probate court possible to bring a claim into is the one described on the birth certificate. They won't do that. The executor office is the highest office in trust law and the highest authority. The estates are the authorities. All other courts are courts of inferior jurisdiction. Estate has been probated from the beginning. The birth certificate with the registrar's seal shows that the estate is either in probate or has already been probated. David Clarence thinks it has already been probated. The birth certificate is the certification of a death and the creation of an estate. Since the seal and signature is on the certificate of birth, that is certified proof that the estate has been probated. It must be an estate, because a trust cannot precede an estate. Fiduciary duty of all officials to the estate. All officials and government servants have taken an oath. Even if they have not taken an oath on record, they have cashed a paycheck and accepted the responsibility. The fiduciary duty of all officials are to serve and protect the estates and the occupant of the executor office. A fiduciary responsibility is the highest responsibility in law. An SF-61 is required in the employee jacket of all federal employees. It is their oath of office. They signed it on following superiors' orders and not the Constitution of the United States is now their problem. Their oath of office is a confession of judgment. http://www.exa.gov/portal/forms/download/75 BO0157F1 AC-5256CF706C379. Who may occupy the executor office until you come of age. Your father has the authority to occupy the executor office of the estate bearing your all-caps name, provided he is aware. Upon attaining the age of majority, 21, you may step into and assume your proper capacity in the executor office of the all-caps name, estate. If a man gets married before he reaches the age of 21, he does not have to wait until he becomes 21 to occupy the office of executor of the estate, but rather can occupy it immediately upon becoming married. As the grantor of the estate, you are the only one who can appoint the executor or assign its duties to someone else. The executor can appoint trustees but cannot authorize fictional entities to administrate the estate. You cannot function in the executor office of someone else. If you give someone the authority to carry out your executor duties, they could get you into trouble or jail. The father may give the mother of the children a specific and general durable power of attorney, made from executor office to executrix office, granting full and exclusive authority in all forms involving all issues regarding name of children, which are property of the husband's estate, except as stated above. The executor cannot delegate authority from the executor office to sign for the estate. In the absence of someone, either your father or yourself, occupying the executor office of the estate, the court will step in and administrate the estate, act like trustee, as if it was abandoned. See definition of executor de tort, above. Until you step up and occupy the executor office for the estate, you are considered to be an incompetent. Acts of an incompetent have no legal effect. So, whatever you did as an incompetent before occupying the executor office never happened, because you had no authority to take any action on the part of the estate. For example, Only the Executor Office can copyright the all-caps estate name, so if you attempted to do so before you occupied the Executor Office of the estate, you were not successful. Until you step up as executor, judges will treat you as a trustee in violation of your fiduciary duties and as liable for debts. A man is the executor of his estate. An unmarried woman is the executrix of her estate. Maiden name means, in a capacity without a husband, unmarried. The estate of a woman married through a civil marriage comes under the estate of the husband, and only he may sign as executor for the wife's estate, which estate is the property of the husband's estate. However, if the husband is malfeasant, the wife may act as the executrix. The wife may sign for her estate as executrix, if she is in a common law marriage or widowed. Also, a woman can be executrix if divorced and she has no father, no brothers of the father, uncles. Children are the property of the father's estate until they reach the age of majority, 21, and even after a divorce of the father and mother. If the father dies, the father's father becomes the executor, and next in line is the oldest brother of the father. The oldest son is the executor of the parents' estates after their death. If a man marries a foreign-born woman with no birth estate, and the wife gets a social security card, now there is a trust that is the property of the husband's estate, and he must protect that trust as property of the husband's estate. If you marry a foreign-born man, you cannot exercise control over a US-born wife's estate. A foreign-born spouse on the public side can inherit the husband's estate upon his death. She cannot function as executrix of the estate upon his death. She brought no dowry to the marriage contract. The husband's brothers would be executor, then oldest son. If there are no heirs on the private side, a foreign-born spouse could occupy the executor office, but if does so with other heirs alive, it's fraud. Social Security Trust. The Social Security card is proof of a trust, not an estate. The Social Security account is connected to everything you do in the world, and all paperwork is directed to the SSN trust, assuming that you are the trustee and therefore have the liability. When being served for collection of a credit card, etc., the Social Security Trust account is being sought. Since you've abandoned the Executor Office, they are probating your estate. They raise a constructive trust in equity to give restitution and reimbursement to the plaintiff and appoint you the trustee. It's all hidden and all fraud. See definition of constructive trust on page 3. The only paperwork that has ever been served on the estate or the executor is the birth certificate. They cannot come after the estate or the Executor Office. The government created the Social Security system so they had a trust where we can be regarded as trustees. Trustees have liability, whereas executors do not. Once you receive a 9 for the estate, it is prima facie evidence of immunity from taxes and attacks, SS taxes, etc. Even then they will always come to you by way of the all-caps name on the SS card. You just have to come back to them asking if they're coming to the estate. You are the occupant of the Executor Office. Never acknowledge you are the name on the SS card. You cannot cancel out the SS trust account. It's estate property. If it comes back to the estate, it won't be earning anything anymore. They are trading off it and will be trading off it after you die. You may eventually profit from the SS trust account. Just be patient. What differentiates the all-caps SS name and the all-caps estate name is that you are designating it as an estate and they are not designating it as anything in particular. Estate property. Don't move anything, property, accounts, over to the estate. Any trusts you create in the world system are property of the estate. Executor Office cannot operate trusts. The best you can do is take control of the property. If your name is not on a deed, you have no standing to operate as the executor. The estate can claim property as property of the estate, and there will likely be no objections. It is believed that all true property titles are abandoned and a process is being tested to reclaim them from where they are being held at a Federal Reserve Bank as assets. Doing business where a license is required. If you are a real estate broker or in some other business that requires a license, you do not set up a trust or other legal entity in which to do business, but rather do everything in your own name. Post Office. General Post Office location. David Clarence has developed the following postal location, designed to make you non-domestic. 1. All caps name, estate. 2. Executor Office. 3. Nation your state. 4. General Post Office. 5. Main Street 100. 6. Any town, last name, province. 7. United States minor, outlying islands. 8. Near 000009998. Note: numbers at the beginning of each line of the postal location have been so placed solely for reference purposes in the line-by-line explanation of the postal location below. Remove the number before using for the postal location. Note: use the street address of the post office, not your own street address for your general post office postal location. David Clarence says to not use the street address for the post office on your executor letters. Use of the post office street address may be considered optional, since prior to the advent of the zip code, a street address would have been required for mail to be sent to that general post office. There appears to be no reason why one may omit the post office street address, unless some vendor insists on a street name and number. While this looks like an address, it is actually a location, not an address. It is a postal location. Historical background of General Post Office. General Post Office has its beginning in Scripture and is established and continued by post treaties. General Post Office is the post office generally. The post treaties are general post to general post. The post office is the largest bank in the world and has the most branches. Branch banks. Jeremiah 51 hours 31 minutes. One post shall run to meet another and one messenger to meet another, to show the king of Babylon that his city is taken at one end. A post is another name for a courier. The definition of the word post originally meant any of a number of riders or runners posted at intervals to carry mail or messages and relays along a route. Post rider or courier, Webster's New World Dictionary, 3rd College edition, 1988. Page 1054. The posts were initially set up for governmental purposes, between different rulers in their own country as well as neighboring countries. But there was another entity, known as the General Post Office, which was not for commercial purposes and was strictly for fellowship between the brothers, and they did it among themselves. Paul's letters were not delivered by Caesar's men, but by brothers in Christ, and that is the General Post Office. Throughout history, there has always been the General Post Office and the Governmental Post Office, and they're different. One's strictly for fellowship, the other for commercial purposes. The current postal system, which is known as the United States Postal Service, is commercial, but it still retains the non-commercial aspect. It's based on the original General Post Office. It does not exist without tracing its roots to the original General Post Office. And as with everything, the created cannot do away with the creator. Therefore, that original creation by the brothers fellowshipping among each other is still in existence. They've never done away with it. In all their statutes, every time they come up with a new statutory entity, they never do away with the General Post Office, therefore it still exists. The General Post Office is not mentioned in the Domestic Mail Manual because the Domestic Mail Manual denotes commerce. Everyone's presumed to be in commerce, but it's only a presumption, and that's where you come in to rebut that presumption. You rebut it by not engaging in commercial activity and not receiving your mail at an address, etc. Most people don't realize that when you receive mail at an address, or even at a P.O. box, you're receiving a free benefit from Caesar. There were actually two different General Post Offices. The Postmaster General today wears about 7 hats, as about 7 different entities to the postal system exist. He wears the original hat as a caretaker of the original General Post Office. He's also the caretaker of the General Post Office that was created on February 20, 1792, which was for governmental business. The Act of February 20, 1792, made detailed provisions for the post office and also established a separate General Post Office for governmental purposes. Chapter 8, an Act to establish the post office and post roads within the United States. Section 3, and it be further enacted, that there shall be established, at the seat of the government of the United States, a General Post Office. Note that this one-page statutory creation by Congress established the General Post Office for governmental business at the seat of the government of the United States in Washington, D.C. The General Post Office, which already existed, was never designated as being repealed in this Act, and has not been repealed in any acts that followed. Therefore, it still remains in existence. separate from the governmental business set up by this Act. Today, the stamp on an envelope pays for delivery of that envelope from the sender's post office to the receiver's post office. It does not pay for the costs when that envelope leaves the area behind the clerk's desk and gets delivered to the receiver's address, mailbox, post office box, mail slot, etc. This is a free service. The alternative to free mail delivery is to receive all postal matter either in general delivery, or through the general post office. The only duty of the postmaster is getting the mail through, not delivery at general post. General post is your post office and you are the postmaster at -9998 and you must go to the post office, to claim the mail matter. Explanation of your new postal location. 1. Name, estate. All caps name, estate. See estate name section above for instructions on constructing your proper estate name. When the estate name is used in the estate mailing location, there should be 4 spaces left between the middle and last name. X, John Quincy Jones, estate. The IRS puts in the 4 spaces when issuing a 9 to the estate. 2. Executor Office. Always type Executor Office as shown. It never changes. 3. Nation your state. For example, Nation Colorado. Enter the state name in which you presently live. Do not put the word of between the word nation and name of your state, thus creating a legal fiction. 4. General Post Office. Always type General Post Office as shown. It never changes. When mail is delivered to General Post Office, mailing location, it is now outside the jurisdiction of the Postal Service. It is now in the hands of the General Post Office. You have moved it out of that domestic realm, outside their jurisdiction, into the private, where you have always been. Non-domestic. Nothing is more permanent than General Post Office, and it's free. They do not deliver. They just surrender the mail to you when you appear to claim it. 5. Main Street, 100. Type the address of the post office in the format shown. The street number is last to put it on the land and out of the United States and corporate state jurisdiction. Describes the mailing location for General Post Office. Again, use of the post office street address may be considered optional. See note above. 6. Any town, estate, last name, province. X. Peoria. Jones province. This is because the geological location upon the land is the estate's land at General Post Office. Province. It is sometimes used figuratively, to signify power or authority, as, it is the province of the court to judge of the law, that of the jury to decide on the facts. Bouviers Law Dictionary, 1856. A province is a prepositional unit, almost always an administrative division. Preposition. The act or an instance of proposing, or placing before. Anything placed before something. Webster's New International Dictionary, 2nd ed. Etymology. The English word province is attested since about 1330 and derives from the 13th century Old French province, which itself comes from the Latin word provincia, which referred to the sphere of authority of a magistrate, in particular, to a foreign territory. A possible Latin etymology is from pro, on behalf of, and vincia, to triumph or to take control of. Thus a province was a territory or function that a Roman magistrate held control of on behalf of his government. This, however, does not tally with the Latin term's earlier usage as a generic term for a jurisdiction under Roman law. Legal aspects. In many federations and confederations, the province or state is not clearly subordinate to the national or central government. Rather, it is considered to be sovereign in regard to its particular set of constitutional functions. The central and provincial government functions, or areas of jurisdiction, are identified in a constitution. Those that are not specifically identified are called residual powers. In a decentralized federal system, such as the United States and Australia, these residual powers lie at the provincial or state level. Wikipedia. 7. United States Minor, Outlying Islands. Type as shown. Explanation of United States Minor, Outlying Islands. Use MOI. The use MOI are country locations, but they are nation-states. United States is minor to the outlying island nation-states surrounding them. USMOI is recognizing the estate as a nation-state located on the USMOI instead of the corporate state of XXXXX. It is non-domestic, It is international. United States minor. Outlying islands can be abbreviated as When filling out a form online, if there is a country field, scroll down and see if there is a use MOI or Selecting United States puts you in the District of Columbia. If the site won't let you add -9998 to the zip code, then just leave it off, but be sure you get use MOI or some form of that on the form. It's referred to as a mailing location. Use MOI do not include Guam, American Samoa, etc. They are described as territories. The CIA Fact Book states that the United States minor, outlying islands is not a description exclusive to those Pacific islands. We are each considered to be an outlying island. All of the islands are in the Pacific, except for Nassau Island, which is in the Caribbean. Here is a list of the islands: Baker Island, Howland Island, Jarvis Island, Johnston Atoll, Kingman Reef, Midway Atoll, Nassau Island, Palmyra Atoll, Wake Island. The Pacific Islands have never been inhabited by permanent residents and consist of temporary, transient scientific and military, mostly Navy personnel. The importance of this fact is, the Bureau of Census does not maintain any records for this location, and this is a big issue. There are no U.S. citizens with permanent residences there. Who does the United States, Incorporated and its corporate states claim control over? Here are some additional statistics, but remember that this is worded to delude the public mind. The United States minor outlying islands, a statistical designation defined by the International Organization for Standardization's ISO 3166-1 code, consists of 9 United States insular areas in the Pacific Ocean and Caribbean Sea: Baker Island, Howland Island, Jarvis Island, Johnston Atoll, Kingman Reef, Midway Islands, Nassau Island, Palmyra Atoll, and Wake Island. The Caribbean territories of Bojonva Bank and Siranilla Bank can also be included as per U.S. sources. Among them, Palmyra Atoll is the only incorporated territory. As of 2008, none of the islands has any permanent residents. The only human population consists of temporarily stationed scientific and military personnel. The 2000 census counted 315 people on Johnston Atoll and 1 person on Wake Island. 1. There has been no modern indigenous population, except at the 1940 census. The Baker, Howland and Jarvis colonization scheme attempted to settle Americans on those 3 islands beginning in 1935. But all 3 islands were evacuated in 1942 as a result of World War II. The islands are grouped together as a statistical convenience. They are not administered collectively, nor do they share a single cultural or political history beyond being uninhabited islands under the sovereignty of the United States. They are collectively represented by the ISO 3166-1 Alpha 2 code. The individual islands have ISO 3166-2 numerical codes. See ISO 3166-2. The Internet Country Code Top-Level Domain, CCTLD. Has historically been assigned to the islands. However, their CCTLD was retired in January 2007. 2. The ISO introduced the term United States Minor Outlying Islands in 1986. From 1974 until 1986, 5 of the islands, Baker Island, Howland Island, Jarvis Island, Palmyra Atoll and Kingman Reef, were grouped under the term United States Miscellaneous Pacific Islands, with ISO 3166 code PU. The code of Midway Atoll was ME, the code of Johnston Atoll was JT, and the code of Wake Island was WK. These links have helped validate the legitimacy of the United States Minor Outlying Islands location when dealing with uninformed or misinformed postal employees. United States Postal Inspection Service https://postalinspectors.usps.gov/forms/fca.asp, country drop-down menu, Securities and Exchange Commission http://www. seconds.gov/edgar/search/campaign-search5.html, country drop-down menu, the Federal Reserve Board http://www.federalreserve.gov/feedback.cfm, country drop-down menu, Department of Transportation http://www.ops.fwa.gov/freight/FAPD/country codes/country United Nations http://unstats.un.org/unst/trade/a knowledge base/comtrade country code and name Central Intelligence Agency https://www.ciad.gov/library/publications/the World Factbook/appendix/appendix d.html Census Bureau http://www.census.gov/geo/www/ansi/state-tables.html Department of Labor https://www.dol.gov/oap/dlhwc/balnation63009.htm8 near 0009998, for example near 80611 9998, use the word near followed by a period before the zip code. Put all zip codes in brackets. All zip codes have entanglements with the postal system, the IRS and the world. Brackets remove it from the page. The zip codes 0000 through -9997 are on the public side. The postmaster has two functions, public side and private side. 9999 is the postmaster's private zip code extension for the postmaster of the Postal Service or for general delivery on the public side. 9998 is the private postmaster designation of the postmaster at General Post Office, on the private side, because the General Post Office is the estate's post office. Using 9998. The postmaster is the occupant of the executor office, that is, you. It is now believed that there is a special zip code reserved for each county that will not appear as a valid zip code. This is because that zip code is reserved for the private side or lands adjacent to the corporate county zip codes. Use by anyone else will constitute mail fraud and will be investigated by the United States Postal Inspector. A list of these special zip codes is being sought. Note: at the end of the text presented on each of lines 1 through 7 of the postal location, there must be a period, as well as after the word near on line 8, so attorneys can't slip in additional information. Changing your mailing. Before you send executor letters, you must change your mailing. You do this by sending a letter to the postmaster and also by changing all your present mailing addresses, home address, post office boxes, private mail boxes, etc., to your new General Post Office mailing location. The problem with private mail locations, such as a UPS store, is they have contracts with the Postal Service and the private mail service is your mail receiving agent. There is an eternal record that you've received mail there. And now you have a conflict. One domestic, one international location. The private mail location is actually a satellite office for the Postal Service. It is fatal to your sovereignty because a delivery takes place there. The contract that you have with the UPS store, etc., is linked directly to the address that you provided when you entered into that contract on PS Form 1583. If you want to sever those entanglements, you must have your mailing location at General Post Office. You cannot get out from under the Postal Service by using a private mailbox, that is UPS store. To assure that you're occupying the executrix office will be respected by the legal system, you must complete and serve the executrix change of mailing location letter, see Exhibit A, on the postmaster at your local main post office, not at a satellite or branch retail location. It must be a post office with a postmaster. Go to http://web.usps.gov/ to look up the name of the postmaster in your area. This database does not identify post offices by zip code, so if you live in a metropolitan area, where there are several post offices, you may have to call your post office to discover the postmaster name. Only the original of the letter needs to be sent by certified mail to the postmaster and copies sent to notify court cases, collection issues, financial institutions, insurance companies, any government entities etc. All other color copies of the Executor exchange of mailing location letter can be sent by regular first-class mail. Once the location change is accepted by the postmaster receiving the executor, executor exchange of mailing location letter, you should get a confirmation number at General Post Office. If you have received no positive response to your change of mailing location letter 14 days after receipt by the postmaster, file a complaint with the Attorney General and Governor referencing the location change. You may provide someone a power of attorney to pick up your mail at General Post Office. See Exhibit B. The postal location on the letter puts you in the nation and out of the state. Being located at the General Post Office makes you non-domestic to the United States. Only use a General Post Office mailing location. Placing your home address on the mailing location is fatal to your effort to occupy the executor, executrix office. Using any other postal location, like your home, a post office box, or a private mailbox nullifies the legal status of being international and independent of the United States. You must also notify every governmental and banking entity, driver license, registration of boats, planes, athletic clubs, church, everyone and thing that you have any affiliation with. Take the numbers off your house, remove the mailbox, and take away the welcome mat, so the authorities no longer have any authority. The mailbox, address and doormat are an open invitation for the authorities to exercise their deluded authority. If you leave that residence address, mailbox or receptacle and house number in place, it is an open invitation to zoning enforcement, process servers, tax and other revenue collectors. You can hang a civil flag of the US on your property. Hang it down, not from a pole. Understand that postal matter at General Post Office is not delivered, it is called for. You are the grantor with the footprints. You are functioning as the occupant of the executor office with the fingerprints. You may need an ID to pick up your mail matter. If your ID has your old address, then you've not changed it. You can use all kinds of ID. Use one with General Post Office address on it. Everyone must follow his or her own path. David has been located at General Post since 1994 and says he has never found an advantage to do otherwise, and in fact he can only find legal disadvantages to having mail delivery at his home. The street name and number used in the mailing location to General Post Office is not necessary. The mail will go to wherever the zip code is. However, some entities will not accept an address to General Post Office and require a street name and number. In that case you can use the street name and number of the post office building. The address must be a main post office, not a branch. Put the mailing location on everything you can. Because you are in the highest office, why would you go get some inferior government officer to certify your executor letter? You do it yourself by getting the post office to do it using the certified mail number sticker. That correspondence has been certified by the United States Postal Service for your General Post Office and the postmaster position of the executor. Post office will accept delivery of UPS and FedEx, or you can have UPS and FedEx delivered to a friend's home or other address that is not yours. Concerning trusts, if the creator of the trust is alive, the trust is estate property. The trustee mailing location needs to be changed. You're not necessarily changing the location of the trust. Sending and receiving certified and registered mail at General Post Office. It is suggested that you use USPS International PS Form 2865 instead of Domestic Form PS Form 3811 when sending certified. Return receipt requested. You can sign for incoming certified and registered mail at General Post Office. If it is addressed to the estate or executor office, then sign as executor or executrix. Examples of why you must be located at General Post Office. Review these code sections to understand how the proper mailing location benefits your tax status. Title 26 greater than Subtitle B greater than Chapter 11 greater than Subchapter A Part 1 greater than Section 2001 Section 2001 Imposition and Rate of Tax. A. Imposition of tax is hereby imposed on the transfer of the taxable estate of every decedent who is a citizen or resident of the United States. Section 2002. Liability for payment. The tax imposed by this chapter shall be paid by the executor. Title 26 greater than Subtitle B greater than Chapter 11 greater than Subchapter C greater than Section 2203 Section 2203 Definition of executor. The term executor, wherever it is used in this title in connection with the estate tax imposed by this chapter, means the executor or administrator of the decedent, or, if there is no executor or administrator appointed, qualified, and acting within the United States, then any person in actual or constructive possession of any property of the decedent. www.law.cornell.edu/use code/26/use_seconds_26_00020020000. HTML. Thus, if you are the executor of the estate of the decedent, whose mailing location is outside of the United States, making it not a resident thereof, you as the executor owe no tax. What to do if the postmaster resists changing your postal location to General Post Office? First, understand that it is unlikely that the person you speak with at the post office has ever heard of the term General Post Office. When I went to the post office, about 10 days after I mailed my change of mailing location executor letter to the postmaster, my home delivery had already been stopped for about a week. The counter clerk, although trying very hard to be helpful, had no idea what I was talking about. I kept talking about General Post Office and he kept repeating General Delivery. Then he passed me off to someone from the back room. This person was very friendly and helpful. At first we went through the same back and forth conversation. I'm here to pick up my mail at General Post Office. Postal guy: so, you want mail from General Delivery? Me: no, General Post Office. Postal guy: right, General Delivery, and so on, and on. Finally, I explained to him that I was aware that he had probably never heard of General Post Office, which he readily admitted to, and that it was not to be found in the domestic mail manual, but that it has been part of the mail system since before the first postal statute was passed by Congress. I explained that I knew people all over the country who receive their mail exclusively by General Post Office, and many have been receiving mail in that manner for decades. He went in the back room for a bit and came out with some mail being held as General Delivery, since no one at the post office knew any better. He told me that he had made the change of address to General Post Office. I asked if I needed to ask for my mail at the counter or ring the bell on the door to the back room. He said just ask for it at the counter and it would be held in the postmaster's office. If after 14 days, the postmaster refuses to change your mailing location to General Post Office, send a letter to the Inspector General. See Exhibit C. Also send a complaint in the form of an executor letter to the Governor and Attorney General in your birth state and the state where you live. Send them certified. Notify the postmaster that complaints are pending before the Inspector General's office. General Post. Postmaster General is a member of the governing board of the post office. Notify everyone of your change of mailing location. When you change your mailing location, notify everyone who you do business with and your friends and family of your change of address. Once you change all your records where you have attachments, driver license, car registration, titles, court cases, bank accounts, employment, etc., it denies them jurisdiction in everything. You cannot take advantage of the Foreign Sovereign Immunities Act with a domestic mail location. If in a court case, notify everybody of the changed mailing location by certified mail: the clerk, prosecuting attorney, the court administrator, pre-trial, probation services, etc. It takes away the court's jurisdiction over you. Do not send a change of mailing location to an offending party. The change is already on the executor letter. The change goes to the postmaster so that when the offending party checks for valid, international, mailing location, there is no conflict with your domestic, home delivery address. This could be fatal. One person's experience at the post office. One man included the executor letter, without the reference to abandoned paperwork, with his change of address form, informing the postmaster at 9999 that he was changing the mailing location of the estate to General Post. He went to the post office and asked for his mail and was told that they did not have it, because it would have to be received at another post office and they were working on it. He got a phone call from the post office that afternoon. They informed him that they had received it and were working on making the change. The next day he received 2 phone calls. On the first phone call he was told they had located where the post office was and they were working on making the change. On the second call he was told the change was complete. He was given a phone number to call to check for incoming mail. When he calls or goes to pick up the mail, their demeanor changes when he tells them his name. Some examples of successes using the executor letter. Example 1. Child custody case. A husband and wife going through nasty divorce were involved in a child custody case. Wife had brought baseless, but damaging allegations against husband. Wife hired a lawyer. Lawyer turned out to be the son of the judge hearing the case. Child services got involved and decided that the husband could only see the children, under supervised visitation for 20 minutes once a month. It was clear that the wife was going to be awarded full custody of the children at the court hearing. Father filed documentation that he was the executor of the estate. When the parties went to court, the father was recognized as executor of the children's estates and the children as property of the father's estate. Father was awarded custody of the children. The next day the judge's caseload was stripped from him. He seems to be removed from the bench. Lawyer has disappeared. Governor of the state has dispatched 2 special agents, who have contacted the father, to the county apparently to put the court system back together again. Example 2. Man on trial set free and case dismissed. A man in jail awaiting trial the next day calls wife, who had received a sample of the executor letter. Wife reads executor letter to husband, who writes down every word. Man writes out executor letter in longhand and signs in front of notary. Man goes to court next day, and presents executor letter to judge. Judge reads letter and immediately instructs bailiff to release this man and get him out of his court. Man goes free and case is dropped. Example 3. Man accused of practicing law O license gets out of jail. A man who was charged with practicing law without a license was sent to jail. He presented the executor letter and got out of jail. Example 4. Foreclosures stopped. At least 2 cases have been reported where foreclosures were stopped using the executor letter, and another foreclosure was stopped in Maryland just before we went to press. Example 5. Stopped garnishment and taking of payroll taxes. Bob had been garnished by the IRS 3 times. He sent executor letter to the CFO of his company. The day after the company got the letter, everyone suddenly started acting cold towards Bob. Bob got a 9 for his estate with him as executor. His immediate boss came back from vacation and was not as friendly as usual. Bob gave her the 9 for the estate. She took it and was shaking. She reads that Bob is dead and yet he is the executor of the estate. She sent the 9 to corporate. Bob gave her another copy of the executor letter and told her to inform payroll they had no authority to deduct anything from estate property, his check, other than medical insurance premium payments. The next business day, everyone at the company is once again talking to him and calling him sir, even though Bob is not management. Then Bob took a W-8 pen for the estate to remove the social security number from the payroll account. He had been garnished the previous week. The big boss calls Bob in the next day. Boss asks if there is anything they can do for Bob. Ends up putting him in the job position he wanted and he now is required to work fewer hours. Bob went back to see his immediate boss to see if the records had been properly changed. She said, I really don't understand all of this, but it is a foreign entity, and corporate is taking care of it. She then told Bob that the CFO was fired yesterday. The CFO was fired because he lost his bonding. He had allowed the garnishment after receiving the executor letter. The executor letter is a lien. It's a judgment by the court, from the post office of the estate, from the postmaster in the executor's office, certified, recorded and registered. Only the board of directors can fire the CFO. The estate may try to bond the CFO so he gets his job back. Example 6. No jury duty. Same Bob as in example 5 used executor letter to get out of jury duty. Example 7. No county refuse fees. Same Bob lives on a farm got rid of refuse fees from the county. Example 8. Plentitude. One person knows 20 people who have had the executor letter work every time. Example 9. Release from jail. A man in New York was released from jail on criminal charges after presenting the executor letter. Example 10. Credit card case dropped. A guy back east went to court with his executor letter in hand, turned it into the court, and then gave a copy to the plaintiff's attorney. The attorney read the letter, then visibly began to shake. Attorney immediately called the judge on the case, and the judge entered a default judgment in favor of the defendant. Example 11. Foreclosure stopped. In Texas, the homeowner sent the executor letter to the Office of Court Administrator on the 28th of October 2010. It was received on the 11th of January 2010. The homeowner attended the non-judicial foreclosure sale on the 11th of February 2010 and presented the executor letter to the substitute trustee. The trustee called someone and then announced that the house was no longer for sale. It was later verified that the house was no longer on the foreclosure list. Example 12. Dad Springs son from jail. A father used an executor letter to remove his 18-year-old son from jail. Example 13. Case dismissed. A man in San Rafael, Marin County, California reports that he was awarded a traffic citation to which he responded with an executor letter to the Office of Court Administrator, Judicial Council of California, San Francisco, California, and hand-delivered copies of the letter to the presiding judge, Marin Superior Court, and District Attorney the morning of court. The judge called the case and announced that it had been dismissed. Example 14. Don't come back no more. A defendant in Tennessee went to court and told the judge that he was the executor of the estate. The judge immediately left. The judge, still in his robes, waited for him outside and told the men to please not come to the court anymore. Just send in your paperwork from now on. Example 15. Son released from jail. Man got son released from 3 weeks in jail with no charges filed by police. Kentucky. A non-success example. A man was charged with filing UCC liens. The executor letter was filed and the case settled. After 3 weeks the guy couldn't take the suspense anymore and filed some commercial paperwork. The day the court got it, they issued a warrant for his arrest. Now he is in jail for 6 years. How to respond to inquiries about the estate. If anyone asks questions about the estate, say, I cannot answer that. It is a private estate and I am duty-bound to non-disclosure concerning the business of the estate. If someone demands the death certificate for the estate, produce the birth certificate with the registrar's seal and signature on it. If they say it's a BC, ask if they can read the seal and signature on the document. The registrar is the probate court. Obvious. The seal on the BC is factual evidence that the estate has been probated. If judge or someone says you did not go to court to become the executor, show them the BC and point out the seal of the registrar. That proves you did go to court. How to execute documents. When signing the executor letter, sign your name as follows. By executor, your upper lowercase name signature. Use all given names and family name. Note, you may also sign in all lowercase letters when signing any other document, including checks, driver license, traffic tickets, etc. Sign your name as follows. Do not insert the word executor. By your upper lowercase name signature. Note, you may also sign in all lowercase letters. Signing your name this way removes all liability and has the same effect as UCC 1308, all rights reserved. Abandoned paperwork. When a party sends paperwork addressed to the all-caps name, they are addressing the estate and assume the estate is abandoned, hence the term abandoned paperwork. When you return their paperwork to them, you are returning the evidence of their attempt to defraud the abandoned estate. They assume the estate is abandoned until you step up into the executor office and notify them with the executor letter. They deliberately leave the words, executor, estate, trust and trustee off the paperwork they abandon and direct to your attention. Everything is unauthorized, unless the executor office has delegated in writing such authority. Anything they send you is abandoned paperwork and it is a fraud, not a mistake. They use only a name on their paperwork without any designation as to what it is. That is estate, executor office, occupant of the executor office, trust, trustee, occupant of the trustee office. You may regard the name as an estate, or whatever you wish. Paperwork sent to the all-caps name which does not distinguish what it is void for vagueness. All the paperwork we receive is directed toward the trust. The trustee has liability. So, when you respond, as trustee, you have already lost. Since the documents do not say named trustee, you have the discretion to assume it's the name, estate. Therefore they are attacking the estate and they have all the liability. So if you regard the name on the paperwork as the estate, they have no authority. They cannot come after the executor. What to do if you have not been sent paperwork? If someone files a document in the office of the county recorder that trespasses on the estate, but did not send you a copy, like a lien or lispendence, get a certified copy and return it with the executor letter. The abandoned paperwork is to be paper-clipped to, not stapled to, the executor letter. Executor letter: when you receive written correspondence addressed to the all-caps name, it is addressing the estate. Anytime anyone is addressing the estate and attempting to take anything from the estate, the issue is trespass. The only response to written correspondence, abandoned paperwork, addressed to the estate is to reply with the executor letter to which you attach, do not staple, the document that has been abandoned on the issue. X. If you receive a collection letter, foreclosure notice, complaint, summons, information, etc., attach, do not staple, it to the executor letter and mail it as described below. If you are in a court case and are just now discovering this process, make a copy of the charging document, that is, complaint, indictment or information, the bond agreement if you were arrested and released on bond, and the judgment if the case has already been decided, and attach. Do not staple them all to the executor letter. Executor letter puts them on notice that you are aware of the estate and now occupy the executor office. We want them to repent and forsake their evil ways. Conflict generation, etc. The recipient of the executor letter has 3 days to act on it after receipt. The executor letter is private, not public or commercial. It is not recorded anywhere. Don't get involved with commercial processes, UCC, trusts, etc. A trust is inferior to an estate. Trusts are created from estates, not estates from trusts. Trustees have liability. Executors do not have liability as they are only the signatory for the estate. Estates are in law. Everything else is fiction. They go after us as trustees and trick us into that capacity. You cannot mix the two. Executor v trustee. It's the same as mixing private and commercial. Always direct the letter to an office occupied by a living being, not the office of the Bureau of Taxes, but to the director of the office of the Bureau of Taxes. The executor office operates with no limitation of time, subject matter, or authority. The executor office can undo any defects done to the estate. It is a duty to correct errors. Note: when replying, make no demands, except for their authority to administrate the estate. In the executor letter, we do not threaten or go to war with them. Paragraph 2 of the letter. They've got nothing but liability. This letter is about making peace. Do not use the estate letter for commerce. It is to be understood that every time a new issue comes up where the estate is being attacked, you must send a new executor letter to those threatening the estate. Do not combine multiple cases or issues in one executor letter. Use a separate executor letter to address each case or issue. Generally speaking, the executor letter should go to top management level for best results. It is likely that the lawyers, on and off the bench, are the ones who best understand the seriousness of the estate fraud issues that can arise if the assault of the estate continues after notification by executor letter. Always mail the original of the executor letter by certified mail, U.S. Postal Service certified mail, PS Form 3800, with a green card, PS Form 3811 or pink PS Form 2865. The original goes to the office to which it is addressed. Do not allow the postal clerk to affix a postal meter strip on your envelope containing an executor letter. Only use stamps to lick those who have trespassed on the estate. The postal clerk will try to convince you to accept the metered postage. Just explain that the reason you want postage stamps is because no one collects metered postage. Only stamps, because they have intrinsic value. Using metered postage invalidates the General Post Office United States minor, outlying islands location. A metered postage is fatal. Normally a court case never closes. Executor letter seems to close the case on the public side. Commercial trading of the securities that are issued the case on the private side, probably continue. Especially if you've signed any documents. Your signature is gold and they won't throw away the notes with your signature. They won't return the note to you either when they are paid off. If a note is produced in court as proof of debt, the judge must sequester the note, take it out of circulation, before he issues a judgment against you to pay the debt, or approves a foreclosure that was just proven with that note production. If you are sending the executor letter to an entity that is withholding benefits from the estate, while they acknowledge the validity of the claim, or are allowing partial benefits to the estate, such as partial disability payments, etc., you should include the paperwork showing they acknowledged the valid claim, but don't call it abandoned, arrogated, alleged, erroneous, etc. Don't nullify that good paperwork. Say that you are hereby warranted and this claim is hereby approved. The claim is hereby adjourned. Leave in all references to their bonds, showing you are aware of all that stuff. It is threatening their bonds without threatening them. Think of the beauty of a prison inmate doing the executor letter. There is a notary public employed by the prison system, notarizing a document that they have proven the identity of the person holding the position of the executor office, and they are holding him as inventory. Example, if one was to have been issued a search warrant, an indictment, an arrest warrant, and finally a criminal case filed, a separate executor letter would be issued for each proceeding. If you get a letter from the state court administrator stating we are not the trustee of your estate, it is an admission they have no jurisdiction. So why are they raiding the estate? Record that letter at the county recorder, get a certified copy and file it into the case. If you made a mistake on the executor letter, just send another one properly done. It replaces the previous one. Do not use all rights reserved or all rights retained. Those are each worldly concepts. You do not want rights, you want all the liberties, and you already have them. People who reserve their 29 of 43 December 5, 2010 rights want to be sovereigns, and by reserving their rights deny them. Any of this stuff is fatal to the executor letter. Explanation of the executor letter line by line. General. The executor letter must be on legal size, 8.5 by 14. Paper, and it's best to use a color laser printer. There is no such thing as a legal document on 8.5 by 11 papers. Congressional bills are presented on legal size paper. We are not going into the courts, so we do not want to use the 8.5 by 11 paper they use. The courts use 8.5 by 11, because they are no longer lawful or legal courts. We use blue ink, because it is royal law. Black ink is used in commerce and is dead and without life. Type the executor letter using 12-point font. Put all zip codes on the executor letter, even their zip code of the person to whom the letter is addressed, in brackets. All zip codes have entanglements with the postal system, the IRS and the world. Brackets remove it from the page. Executor's return address, that is, mailing location. See section above General Post Office location for instructions regarding the mailing location. The mailing location at the letter heading and again below the executor's signature must be the same, and both are required. If you don't put the mailing location below your signature, the barflies will assume you are located in the notary public office, back in the world. Date of executor letter. The date of the executor letter is done in the manner shown, that is done by the light of the day of 22 October 2010. Certified mail number strip. The certified mail number strip should be peeled from the certified mail receipt and placed on the letter between the dashed lines. The space between the dashed lines is a right of way. Make sure the dashed lines are outside the strip, so they can be seen once the strip is in place. Since it could be construed that the outside edge of the certified mail number strip makes it not appear on the page, we put the passing lanes outside the certified mail number strip to defeat that possible assertion. The certified sticker on the executor letter attaché is the bond of the postmaster. The certified mail number strip certifies the document. After the notary public notarizes it and records it in the notary register, it is a registered certified document. You now have 3 records, 2 witnesses, notary and U.S. Postal Service record. You only need 2. Addressee general. Always direct the letter to the office occupied by a living being. Executor office always deals with the administrative office, because the executor office is a court. It is an administrative office, but it is a judicial office also. Always address the lawyer at the top of the food chain, if it is not a court issue. For court issues, do not file a copy of the executor letter with the court. The office of the court clerk is to serve the lawyer industry, not you or the estate. Never give them anything. Never send the estate letter to a judge, always to the state court administrator or highest lawyer in the food chain, etc. The governor and attorney general of the birth state are probably trustees over the estate. The attached table, Exhibit D, who gets the executor letter, shows where to send the original and copies of the executor letter in most common circumstances. Also attached as Exhibit C, K are 6 examples of the most common uses of the executor letter. Address of addressee explained line by line. 1. Officer, for example court administrator or chief counsel or chief financial officer. This is always the office, not the department, agency, corporation, etc. The executor letter is a communication from the executor office of the estate to their office, office to office. The executor office is superior to their office. This is not a personal communication. It is office to office to office. 2. Attention, name of occupant of office. For example, John, public servant. This is always the name of the person occupying the office stated on line 1. 3. Corporate location, state/federal court or financial headquarters. For example, United States District Court for the District of Colorado. This is the name of the court or corporation. 4. 10. Public square. For example, 101 Commerce Street. 5. Any town, state. For example, Denver, CO, XXXXX. For example, USA, 80,212. 6. USA. Even if you send the letter to Washington, D.C., put USA before the zip code and put their zip code in brackets, because you want to separate this communication from the United States. You want to remain non-domestic to the U.S. foreign corporate entity. You do not want to drag the estate or the executor office into the world system. Note: the line numbers above are for reference purposes only. Remove line numbers for application to letter. 2. Enter the same information as was entered in line 1 of the address of the addressee of the letter. X. From above, Office of Court Administrator. From X, Executor Office, all caps, name, estate. Regarding the first line of the 2 section is the same for both the executor and executrix signing for the estate that bears their all caps name, as follows. X, unauthorized administration of all caps name, estate. The second line. 1. For both the executor and executrix signing for the estate that bears their all caps name, and 2. The third line for the executor signing for the estate of his wife or children, are both prepared the same. It must identify their court name and docket, financial account or tax number, etc. that identifies the issue. X, Douglas County Courts, case number 10 CV00404. Note: leave the brackets. The third line, which only applies to the executor signing for the estate of his wife or children, must provide the all caps name, estate of the wife or child estate, the file number found on the birth certificate, and the name of the birth state. X, being there, My Honey Bunny, Colorado birth certificate file number 34893, estate. Note: leave the brackets. If you have 2 birth certificates, one recognized and the other, original before an adoption, not recognized, use the recognized one and reference the other in the read line in brackets. Note: the information inserted in the to and from fields ends with a first paragraph of executor letter. The purposes of this paragraph are to identify the person who signed the abandoned paperwork, to issue an order, and to adjourn the false claim. Paragraph 1 of the executor letter is an allocution, formality of court's inquiry of prisoner as to whether he has any legal cause to show why judgment should not be pronounced against him on verdict of conviction. Black's Law Dictionary, 4th ed. The name of the person who signed the abandoned paperwork goes in this paragraph, along with his, her title, and state bar card number, naming the state that issued the bar number, if a member of the bar. X. Gunnar Bluff M., Attorney at Law, Colorado, bar number 30293. See section entitled Abandoned Paperwork above for discussion of that topic. Adjourn means closed. This is a court ruling by the executor office. It is the court ruling. You are the judge of the court. The actions and abandoned paperwork have been overruled by the court. In this paragraph you may also issue other orders, such as, you are hereby warranted by the executor office to cease and desist this fraud or seizure, the sale of the estate, property. This matter is hereby adjourned. Go here to find the bar card number for State of Colorado attorneys, http://coloradosupremecourt.com/search/at-search.asp. Second paragraph of Executor Letter. The purposes of this paragraph are to demand the written delegated authority to administrate the estate and to demand copies of bonds, sureties, indemnification, insurance and CRISC-USIP numbers, etc. In so doing, a lien has been placed on those sureties. Paragraph 2 of the letter demands their surety by threatening them without a direct threat. The name and title of the person occupying the office to which this executor letter is addressed is named in this paragraph. Concerning the Court Registry Investment System, CRIS, the July 2007 CRIS report by the Administrative Office of the United States Courts, the Court Banking System, is posted in the discussions thread of the Google group. It shows the reality of the CRIS system. Within the report you will find the entire structure of this system, detailing its hierarchy, chain of command and flow charts describing how the funds flow. Notice that a minimum transfer of funds from a court to CRIS is $50 million. What court would have $50 million to deal with except for bonds being issued on each case? Right in the report you can see case numbers and CUSIP numbers assigned to the financial transaction and the bonding and profits derived from the unknowing victims, that is, defendants. Note that CRIS held a 2007 balance in excess of $2 trillion. $2,000,000,000 until after conviction, sentencing. The financial transaction part of the claim docket is kept in the judge's chambers. After sentencing, that information is entered by the clerk and is sent to Texas. Certified document. At the bottom left of the document, where it says certified document, do not enter the certified mail number. It is already affixed to the letter. If you write in the number, you have placed a facsimile of the certified number on the letter and have nullified the passing lanes. When you send copies of the executor letter, each one can be mailed certified by adding another certified mail sticker below the original one on the colored copy of the original executor letter. Copy to Office of Governor/Office of Attorney General. On the first line of each copy to. Leave the text exactly as presented. For example, copy to Office of Governor and copy to Office of Attorney General, respectively. On the second line of each copy to, where it says State of, Corporate Birth State, replace the words Corporate Birth State, and remove the brackets, for example State of Colorado. On the third line of each copy to, where it says, Governor's name, Governor or, Attorney General's name, Attorney General, respectively, replace with the name of the persons who occupy the office of Governor and Attorney General, for example John Wilkes Booth, Governor, and Patty Cakes Booth, Attorney General. Remove the brackets. Note, if you were born in Washington, D.C., your birth state is Maryland. If copies of this letter are to be sent to other parties, they can be listed in like manner in this area. Signature of executor. Sign your name exactly as it appears on your birth certificate in upper then lower letters or all lower. Notary jurat. Place a jurat at the bottom of the page in black ink. Make state and county names in all caps. Where to send copies of the executor letter. When the executor letter is completed, signed, and notarized, make color copies to send to the following parties by regular U.S. mail. For all issues, both state and federal, send a copy of the executor letter to the Governor and Attorney General in your birth state. It is the birth state Governor and Attorney General offices that are ultimately responsible for the fraud. They are the custodians of the birth record and must defend and protect it. You may want to also send a copy of the executor letter to the Governor and Attorney General in the state in which the action is taking place, where you live. Again, the idea is that the more officials to whom you provide the executor letter, the greater the chance that someone will perform their duties as required. Additionally, you want to send a copy of the letter to the Secretary of State in your state, so that, if the entity who sent you the abandoned paperwork is not registered to do business in your state, that fact may come to the attention of the Attorney General. The Governor of the state where you live gets a copy because he is over the Insurance Commissioner. The State Attorney General gets a copy because he is ultimately over all of the corporations, trusts and estates of the state. The State Attorney General is the chief counsel for the state and state agencies. For list of state governors www.usa.gov/contact/governors.html. For list of state attorney generals www.nag.org/current attorneys-general.php. When sending copies of the executor letter to governor or attorney general etc., use executor letter format to create a cover letter and say, "Enclosed for your attention. Kindly monitor or intercede in this situation as required." Remove the abandoned paperwork paragraph, but always leave the second paragraph about their bonding. The abandoned documents need only be sent with the original of the executor letter. However, for extra effect, you may send a copy of the abandoned documents with other copies of the executor letter being sent to the governor, etc. Your social security number is attached to the court case, so they know the identity of the estate and the executor. The birth state manages the fiscal health of the estate through the state treasurer. The birth state already has the CRISC-USIP accounting of every case the day after it's filed on the treasurer's system. The states have a reciprocation agreement regarding information concerning the estate and executor office. The Office of Risk Management is over everything: courts, feds, IRS, etc. 441 4th Street, NW, Washington, D.C. 20001, USA. http://om.dc.gov/om/site/default.asp. Be very careful filing claims with the above office. Could get you assassinated. Sending the executor letter is a claim against their bonds. Don't send it to the above office. Use of the executor letter in specific situations. General change everything that is property of the estate to General Post Office. Never hurts to record something with the county recorder and then serve a certified copy of that recorded document on the other party. Record the change of mailing location and then send certified copies of it when needed. Very powerful. If a case is moved to a higher court, send executor letter to court of original jurisdiction and to the higher court using the new mailing location. You will be amazed at the results of changing the mailing location, especially with ongoing cases. When you return to the land in the executor office, then all the estate property is due to return to the estate because you are now functioning in that capacity. Response to mail address to the estate regarding a court case in the state. For all state court issues, address the letter to the office of the state court administrator, not to the clerk of court. Never file anything into the court case. Stay on the financial side of the court. Court administrators are almost always lawyers. The court administrator of the state notifies all of the state Supreme Court justices immediately. Even if the state court administrator etc. is not an attorney, you still send the executor letter to that office and the occupant of that office, and in paragraph 2 of the executor letter, you still ask for bonds, sureties etc. and bar bonds, because there is always an attorney who represents the office. In Colorado, address the executor letter to Office of State Court Administrator. Attention, Gerald A. Maroney, 101 Colfax Ave, Suite 500, Denver, CO. 80202, USA. The state court administrator administers attorney licensing in the state, so by notifying the state court administrator in the state where the court action takes place, you bring to bear someone who has control over the attorney. Below is the link to find state court administrators. State court administrators http://cosca.ncsc.ni.us/coscapublicroaster.pdf. Response to mail address to the estate regarding a federal court case. For all federal court issues, address the letter to the Administrative Office of the United States Courts. Court administrators are all lawyers. The court administrator for the federal court system notifies the Supreme Court justices and the appellate court judges, and all their bonds are put in jeopardy. They're the ones who swear in all those lawyers and issue them bar cards administratively. That's why you deal with the administrative side of the court and not the judicial side. Creating the bar attorney is not judicial, it's administrative, and where they have all jurisdiction over those lawyers, it's called deep distress. They will probably respond that they have no jurisdiction over an ongoing case, but that is not what the letter is about. See organization at. Read all about it at this website. http://www.usecounts.gov/federal courts, understanding federal courts, administrative office, director annual report/viewer.asps. doc =/usecounts/federal courts, annual report/2009/directors message.html. Office of Director, Administrative Office of the United States Courts. Attention, James C. Duff, Director, Administrative Office of the United States Courts, 1 Columbus Circle, NE Washington, D.C. 20544, USA. If a court administrator refuses to do his job, send him a letter such as Exhibit K, response to a collection letter from an attorney for a credit card account, foreclosure, pre-court, or other administrative issues outside of a court action. If you receive a collection letter or any letter addressed to the all caps name, the estate, for the collection of a credit card debt, mortgage, or any other attempted trespass on the estate, the executor letter should be addressed to the attorney who sent you the letter, for example the chief counsel of the company, or the CFO. Collection agency documents, sent to the Secretary of State for the state, never to the collection agency. Response to a letter from the IRS. Address the executor letter to http://www.irs.gov/newsroom/article/0, id = 1615446,00.html. Office of Chief Counsel William J. Wilkins, Chief Counsel, Internal Revenue Service, Headquarters 1111 Constitution Avenue, NW Washington, D.C. 20224, USA. As in all other cases, the higher up the chain of command you send the executor letter, the more likely you are to get the results you desire. If the issue also involves an employer, you may want to send a copy of the executor letter to the employer as well. When speaking with SID, tell them you are the occupant of the executor office, etc. This matter involves estate property. Where is your delegated authority to administrate the estate? Or where is your bond? One or the other, or get out of here. IRS is not happy about these executor letters. If you don't receive a positive response within 14 days of delivery of your executor letter, file a complaint with the Governor and Attorney General. Feds cannot operate on corporate state without consent of Governor. IRS cannot operate on the corporate county without the consent of the Sheriff. Governor and Sheriff's bonds are at risk. Corporations. Describe a corporation as property of the estate. It was formed under the Social Security Trust. Once you describe the corporation as property of the estate, they lose all jurisdictions over it. Car titles. Send the executor letter to DMV for car title. They will no longer have any jurisdiction to impound it. Change mail location on car title. Traffic tickets. Sign a citation with by signature and prepare an executor letter and return the citation to the state court administrator with the letter. Bank irregularities. If a bank does something improper regarding your bank account, address the executor letter to Chief Counsel for the Controller of the Currency. Bankruptcy court issues. If in a bankruptcy case, you can stop it with the executor letter. If there is an IRS issue, clear that up first. In bankruptcy, submit the executor letter on all underlying financial issues. Then present the letter on the bankruptcy to the court administrator for the BK court and it will be dismissed immediately. The BK trustee will get word of it when the first executor letter goes out and may dismiss the bankruptcy right away. Property taxes. Notifying the property taxing district may eliminate property taxes. Mortgages. Foreclosures. In a foreclosure, in a non-judicial state, address the executor letter to the state court administrator. Copy the letter to the attorney who sent the foreclosure letter, the CFO of the foreclosing bank, and the Governor and Attorney General of the birth state and state where the property is located. Your bank does not like you changing your mail to General Post, because they can't come after you with a foreclosure or for late payments. You can tell the mortgagee, bank, in a foreclosure situation, you are hereby warranted by the executor office to cease and desist the sale of the property. This matter is hereby adjourned. Disability. If you are denied Social Security disability, Send the executor letter to Chief Counsel of Social Security. Order them to issue the disability. Reference the claim number. You are hereby warranted and directed to approve and issue the disability claim in full. This matter is hereby adjourned. Internal Revenue Service. If the IRS seizes or sells property, look for a letter from the manager of ACS, Automated Collection Service, or District Director to send a copy of the letter to. When asked by the IRS to bring your records, bring a box of phonograph records, taped up, and marked outside private estate records, on all 6 sides of the box. They will not open that box. Children. The executor can order the return of a child to the estate. Voting. If you change the mailing location at the election office, you can no longer vote. You are now in the status of elector instead of voter. Release of prisoners. The executor letter cannot be used to secure release of prisoners where there has been an injury to another person or property. Effective executor status on receiving Social Security checks. U.S. Treasury, who has acknowledged that the name is deceased, sends his name's Social Security checks to David's General Post every month. Even though there is a decedent on that Treasury document, the ALCAP's name is a decedent. It is not a corporation. It is a company, if it is anything. The estate is under the birth granting. The benefits are under the Social Security Trust. 2 different statuses, one does not affect the other. Notify the Social Security Administration of your change of mailing location. In the Oh by the way department, always get a paper check mailed to you instead of direct deposit. The face value of the check is not the full value of that security instrument. It is the public side representation. The private side of that check is at least 20 times the face value. Sometime in the future we will show you how to submit those checks and receive a check back for at least 20 times the face value and get the check returned to you so you can cash it. This applies to all checks, even personal checks. It is a paper security. That's why they don't send your checks back to you. The check is in United States dollars. A US dollar is still $1 silver dollar, 1 ounce currently about 27.00 FRNs. Loss claims on airlines, buses, etc. Airline limits of liability are not limiting to the estate. Lost baggage is estate property, so make a claim for the full value. County Recorder's Office. If you have a notarized document that the county recorder won't record, they don't have a leg to stand on. The recorder's records are not just for the attorneys. Write an executor letter, reworded, to the Secretary of State and Governor who commissioned that county recorder, informing them of the non-action and give them 3 days to correct the situation or you'll be claiming their bonds. The recorder, the Secretary of State and the Governor, verbally presenting and enforcing your position as executor while in court. Once you send the executor letter, the issue is not how the executor enforces his position. The issue is that they now cannot enforce their position. Remember that where the estate is concerned, there is no plaintiff or defendant offices, because the estate does not subject itself to a court. They can't come after the estate because it is de jure. They are de facto. When a JS-44 civil cover sheet is filed in a court case, it is in relationship to the SS trust account. http://www.act.us/reference/pro_say/civil_cover_cs-4312008.pdf. If possible, you should mail your executor letter to the court administrator and other appropriate parties before your court appearance. If you are unable to do so, then present the letter to the prosecutor in court. You should have a copy for the judge in case he requests one, and mail it to the other parties ASAP after court. After sending the executor letter to the court administrator, David recommends that you appear in court. If required to do so, just go and sit in the first row of the gallery behind the prosecutor, outside the bar, and when the case, estate name, is called, just hand a copy of the executor letter to the prosecutor, not the judge. Do not enter the bar. Say I'm the occupant of the executor office and to that estate. Spell the all caps name, estate. Do not state your name because that identifies you as the defendant. Stand outside the bar and inform the judge you, as the executor, are not claiming benefit or coverage under the Federal Sovereign Immunities Act, but it is his duty to recognize the act. The estate is in fact the state being described in the Act. Change of mailing location proves the estate is foreign. Never tell your attorney that you are presenting the executor letter. Drop the bomb in court and they will back off. Saying the wrong thing in a courtroom can withdraw the executor letter. Being escorted by a gunslinger inside the bar is okay. Just notify the court that you are being compelled at gunpoint and fear for your life. If you find yourself in court and inside the bar, make your statements such as those below and ask questions. Try not to engage in any other conversation or arguments. When in court, whether or not you already presented the executor letter, as soon as the case is called, announce the following to the court by addressing the opposing counsel: I am here in my proper capacity as the occupant of the executor office of the all caps name, estate. If asked who appointed you executor, just hand them the birth certificate. Turn to the opposing counsel, and say, I demand your written authority to administrate the all caps name, estate. If the attorney gives you any lip, or says he doesn't have the written authority, tell him. 39 of 43 December 5, 2010. I understand that the quickest way for you to get disbarred is to screw with the all caps name, estate. Do you plan on screwing with the all caps name, estate? If the attorney is smart, he will pack his briefcase and immediately exit stage right. If the attorney tries to give you any guff, tell him or her, sir, as the person occupying the executor office of the all caps name, estate, I must warn you that if you refuse to stand down, I will, in furtherance of my fiduciary duties, forthwith file a complaint with the Bar Association for tampering with the all caps name, estate. You may also write out a bill for your time and hand it to the attorney. And, for good measure, you may want to appoint the attorney as a trustee of the estate. Lots of liability. If the judge ignores your position as executor, ask, excuse me, Your Honor, I am a bit confused about something here. Is this a probate court? You can then state, the executor office of the all caps name, estate being the highest office represented here today, I demand that this case be immediately dismissed with prejudice and that all damages owing to the all caps name, estate be paid forthwith. If the judge still refuses to give in, appoint him as a trustee of the estate. Lots of liability. As the occupant of the executor office of the all caps name, estate, I am directing you to dismiss this case and award damages to the all caps name, estate as appropriate. If the damages have already been stated in the paperwork, then you can refer to them and demand that an order to that effect be issued by the court. If the damages have not been stated, and you know the amount, you can state them in court at this time, and demand an order. If you do not know the amount of the damages, then you can advise the court that you will prepare a statement of the charges and file them with the court within X days. You decide how long you need to prepare the charges. If the judge, or anyone else objects to your statement that the executor is the highest office present in the court, or continues to move forward acting as if they have the authority to administrate the estate, after being advised that you are the executor, ask for the written authority to administrate the all caps name, estate of all such persons. If the judge wants to discuss the estate, it must be done in judge's chambers, not in public in the courtroom. If the judge threatens to lock you up, ask him, are you suggesting you are going to put the occupant of the executor office into custody? Is that what you're saying? That would create a constitutional crisis because the US government is founded on and funded by the estates. The estates are the creditor. For all intents and purposes, the executor is the centurion. The occupant of the executor office in Roman law is the centurion and cannot be jailed. At some point in the case you may want to close the case by order of the court and a rap of your knuckles on the table. 40 of 43 December 5, 2010. Don't go into their courtrooms to deal with the fraud. Deal with it in the paperwork that is the executor letter. David simply leaves the past trespasses and frauds behind and believes that the estate has so much to offer you that the delusions and confusions of the world will pale in comparison. Another approach when going into court, from outside the bar, address the prosecutor, adversary, not the judge. I am appearing here occupying the executor office of the estate. Where is your written delegation of authority from this executor office to administrate the estate or the bond for your fraud? Present your authority now. Here is how one man, who did not know about the executor letter until just before his trial, handled his court appearance, and caused the court clerk to abandon the courtroom. Man, defendant, in Illinois involved in willful failure to fill and tax evasion, prepared executor letter and mailed it to the court administrator and then filed it with the clerk in the case record. Defendant went to court on the first day of the trial and stayed outside the bar. The defendant had been appointed a public defender. When the prosecutor came into the courtroom, the public defender handed him a copy of the executor letter. The prosecutor handed it to the bailiff, who handed it to the judge. Then a flurry of activity ensued. They tried to entice the defendant into the bar. Defendant told them he was occupying the office of executor of the name, estate, spelling out the name, and not pronouncing it. The court kept trying to entice the defendant into the bar, over and over. Defendant had the same response, over and over. The judge brought in the jury. Defendant kept stating who he was. The IRS agent was brought onto the witness stand, and prosecution began entering evidence. The prosecutor kept trying to hand the defendant copies of the evidence, but he refused to accept them, so they put them on the vacant defense table. Thus the first day of the trial ended. After court, the defendant changed his mailing address with the post office, and then notified the court of his new mailing location, by notarized letter, by putting it into the court record through the clerk's office. Second day in court, jury came in. A witness was sworn in on the stand. But, the clerk was not in the courtroom. The clerk determines whether or not it is a court of record. A judge cannot do anything if there is no clerk to file the judge's orders, etc. The absence of the clerk was apparently done due to the change of address. This left the lawyers on their own. This situation creates an automatic win on appeal and a reversal on habeas corpus. The prosecution was laying the exhibits of evidence on the defense table. There was no clerk to assign them an exhibit number and enter them into the case, so no evidence was entered into the case. The court took a 2-hour recess at lunchtime. Just after lunch, the public defender asked if the defendant would mind if he went over and picked up the exhibits on the defense table. The defendant told him not to. After lunch, when the judge came in, the defendant said, "Excuse me, Frederick, judge's first name. The occupant of the executor office of the name, estate has some administrative procedures for the court to consider." The judge said fine. When the judge enters the court, he is in an administrative capacity and he has to entertain administrative requests at that time. The defendant told the court that he was there as the occupant of the executor office of the name, estate, and as the court, the jury is hereby dismissed, this financial claim is hereby settled, and clerk is directed to close the file. Then he rapped his knuckles on the bar and said, "Case dismissed, court is adjourned." The judge said, "You can't do that." The man said, "The occupant of the office of executor just did." He turned around to walk out of the courtroom, and as he 41 of 43 December 5, 2010 approached the door, the deputy marshal approached him. The judge told the deputy to let him leave. Then the court finished the trial, again without the clerk. Since there was no clerk present, the court needs the clerk present, and so do you. There was no one to accept the order, but everyone heard what he said in open court. He got a call later that day from the public defender saying that he had been found guilty by the jury and the judge had revoked his bond and issued a warrant. He should have told the lawyer that the public defender had just been found guilty, because the public defender was the one on trial. It is the lawyer who is on trial. The lawyers in that courtroom can only try another lawyer. There was no defendant in the case. That is why the courts say you are an idiot if you go to trial pro se. You are voluntarily putting yourself on trial. That is why they always appoint a standby lawyer, because the lawyer stands in for you. They mysteriously pass the liability on before sentencing. The defense attorney offered to send an investigator out to drive the defendant to court to turn himself in. The defendant laughed and hung up. Why was the public defender warning him of the warrant? If there is a warrant, you do not get a warning. The next day the defendant went to the county recorder to record his orders in executor letter format, since the clerk was not in court during the trial. Then he filed them into the case by mailing them. The defendant got a call from the marshal saying the judge wanted to talk with him. The defendant said the occupant of the executor office had nothing to talk about. The marshal said, "Do you mean you do not plan on surrendering?" The defendant said, "I did not say that. I just have some pressing business to take care of. The marshal said get back to me tomorrow. The next day the local police showed up and kicked in the door. Police cannot serve a federal warrant. They can detain you if they know there is a warrant. The police took him to the city jail and had him incarcerated. Where was the detention order? Only the marshal can do that. The defendant has been at the city jail for over a week. David Clarence is working on getting him out. The lawyers and judge are committing a fraud on the court and will likely be disbarred. Remember, the attorneys have only two cards to play, both jokers, the intimidation card and the deceit card. They use these cards to attempt to get you to cave in a bluff. Enforcement of the executor letter in a court case. Sending the executor letter to the state court administrator, etc., is not about jurisdiction in the ongoing case. It's about their bar card members perpetrating a fraud against the estate. That is the issue. When you send the executor letter to the state court administrator, the administrator's job is to take care of the problem and to bring it to the attention of the judge on the case. The judge will consider it a hot potato with loads of liability attached. He will pass it off to the prosecuting attorney, admonishing the attorney for bringing this problem into his court, and will require the attorney to clean up the mess he caused. The judge will dismiss the case on the request of the attorney, who is charged with righting any wrongs that have been caused to the estate. Once you send in your executor letter regarding a court case, just monitor the docket online to determine what action has been taken. If the judge does not take care of the problem quickly, that is, dismiss the case in short order, you should have already sent a letter to the state attorney general and governor, also to the U.S. Attorney General in federal cases, advising of the fraudulent activities of the court and demanding that the situation be corrected. You may also write a letter to the judge to reinforce the wishes of the estate, and instruct the judge to dismiss the case and award damages to the estate. When or if the court administrator returns your documents, that means they want it to go away. They hope you will not do anything further. When the executor letter is not obeyed by the court, go after the lawyer's bonds, court administrator's bonds, judge's bonds, clerk's bonds. If the state court administrator has been served, go after his bonds and the Supreme Court Justice's bonds. David is working on arresting bonds, QZIP numbers, and other remedies. Do not mix remedies. David Clarence says that once you issue an executor letter in a particular situation, you are stopped from thereafter pursuing other forms of remedies, such as commercial remedies, filing a lawsuit, etc. He says you cannot bring a lawsuit from the estate into court, because the estate is the court. If the estate goes into court, the estate is abandoned. If you use this process to try to collect liens, you are going to prison. You can't mix these two law forms. You cannot collect private judgments with the executor letter. That would be mixing the estate with commercial activities. It is not hard to understand that since the estate is a higher court, you would not want to go to a lower court to ask for a remedy. However, if you do that, you are simply utilizing their court to bring the trespasser into their jurisdiction to seek the replevin. Maybe it would be better form to issue the lower court a writ of mandate instead of filing a complaint. David has cited a case, see above, where a man used a commercial process after presenting the executor letter and then went to jail. Real property title. Land patent is from the corporate government. The estate has first and best title. David thinks he has it worked out. Transfer the deed to the estate. There appears to be special zip codes for mail to land, property with true title. Not land, property with deeds. True title makes the land an island. How to get true title is coming soon. David says it appears that all land is abandoned and he is working on a process by which to reclaim it. Until we each hold our land in LODM versus the abandonment status that everyone's land title is currently under as deeds to real estate, we have little or no standing to change anything. With true title to land, property, it appears you can reclaim foreclosed property from whoever owns it now. Title insurance should make them whole because the title deed was defective when sold to them. Executors as notaries. You only need 2 executors to witness anything. That notarizes the document. They sign as witnesses, write the word seal all lowercase above the signature and sign under it, then place a right-hand red thumbprint so that it covers the word seal completely and touches the signature. By Executor_it is now a notarized document. You have no idea how powerful this